Good morning, friends. Yesterday, the Honorable Supreme Court of India, the bench of the Chief Justice of India, they have dismissed the appeal petition filed by Mr. TEJ Bahadur against none but the Prime Minister of India, Shri Narendra Modi Ji. Shri Narendra Modi Ji. So you can see the case as TEJ Bahadur versus Narendra Modi in civil appeal number 2100 by 2020. Yesterday on 24/10/11/2020, this has been disposed of by the Supreme Court. So actually this is an action petition. You may be knowing. So according to the Representation of the People's Act, the 1951, the election petition has to be filed only before the High Court of the concerned state. So this is what is called original jurisdiction. The High Courts have original jurisdiction in conducting trial into the election petitions. Right? So, of course, this TEJ Bahadur already Allahabad High Court dismissed his petition, and now he has come in appeal by filing this civil appeal, and it is also rejected by the CJI Ram Subramaniam and another judge, 3 judges bench. It has been clearly, yes, right. Now let's go into the details of the case. You will be knowing in the month of May 2019, the elections were held, and Narendra Modi contested from Varanasi. This is second time he contested from Varanasi as the member of parliament. Right? So the nominations, the final day for the nominations was 29/4/2019. So along with others, Mr. TEJ Bahadur, he also filed his nomination for the so-called seat, MP seat. He also contested. Of course, he has filed 2 nominations, one on 24/4 and the second one on 29/4. Right? So you know his background also. He was an employee of the Border Security, BSF. Right? In this BSF, Border Security Force, he was dismissed. We don't know the reasons, whether he was dismissed for corruption or something, but he was a dismissed servant of the government employee. Right? Okay. It is learned that he was dismissed in 2017. Right? So now he filed the petition. No, not 2000. I am not sure about his. Okay. He was dismissed. That's all. Let us confine to that. Right. He filed the nomination, and normally you may be knowing there will be some forms. So according to the forms, the query was that whether he was dismissed for corruption or disloyalty. In the nomination form on 24/4, he said yes, but on 29th, second nomination, he said no. Then the scrutiny has taken place on 1/5/2019. In this connection, the returning officer has given a notice to him to clarify as to whether he was dismissed for corruption and disloyalty. If not, then he has to get a certificate from the election commission. 2014 he was dismissed. Right. So he has to get an election certificate from the election commission that he was not dismissed for this so-called disloyalty and other things. And he did not find time. He said he is consulting the election commission. He has sent a letter on 1/5/19 evening or so. He has sent a letter, but of course time was not given to him. His nomination was rejected. Right? Whatever be the government, his nomination was rejected. Now he has filed an election petition stating that it was wrongly rejected and giving advantage to Narendra Modi, who was wrongly elected. He was wrongly rejected, he was wrongly elected. So his his election should be stalled. That is his representation. So according to section 81, he filed the petition, but according to section 81 says the person who contests or who files the election petition should be an elector, should be a candidate. Here the point is, he is not an elector because his vote is in Bhiwani of Haryana state. Maharaj Pratapgarh or something. He was he had no because his applicant had no lacus time to file the petition. was founded in so he belongs to some other place, that is in this is in Haryana state, Bhiwani. He belongs to Bhiwani. He is not a voter of this place. Secondly, he is not a duly nominated candidate. No doubt, 81 says either should be an elector or a candidate. Candidate means duly nominated candidate. Suppose if his nomination is allowed, if he contested, yes, he has got a right to file an election petition before the High Court. But here his nomination was rejected. So he is not a duly nominated candidate. Right? No doubt, even though he was dismissed 5 years before the election, 2014, yes, he can contest, there is no problem. But the point is, he has to give a certificate from the election commission to prove that he was not dismissed on the grounds of corruption and disloyalty. Even though he wrote a letter, of course, his advocate argued that some time has to be given him only on that 1/5/2019. You cannot take it granted that he has not submitted the letter, all things. So 1 day time is not sufficient, his lawyer argued, but he said no, because now let us take section 81. He is a man, he is a voter from Bhiwani of Mahendragarh constituency in Haryana. So he has no locus standi. Second, he is not a candidate because his nomination was rejected. So therefore, he cannot say that his nomination was rejected and the nomination of Narendra Modi was wrongfully accepted. So basically, that's why Supreme Court said that it is satisfied with the decision of the Allahabad High Court, which nipped the incident in the bud stage itself. Because on behalf of Narendra Modi, Mr. Harish Salve is a famous advocate in Illinois. He argued that the petition filed by the TEJ Bahadur has to be dismissed under Article 6, Rule 16, that is striking of pleadings, and Article 7, Rule 11, that is the plaint should be dismissed because there is no cause of action. It is a frivolous petition, it is a scandalous petition, the petition itself is unnecessary, right? So please remember, so as for section 9 clause 2 of the Representation of People Act, he is a disqualified candidate. So when he is a disqualified candidate, he cannot become a duly nominated candidate. So please remember, these are the sections. Sections are more important because according to section 86 of the RP Act, the High Court shall dismiss an application which is not complied with section 81. Section 81 already told you, the person who is competent to file the petition is only the elector or the candidate. So section 81 is not fulfilled. Therefore, according to section 86, already the petition is dismissed and he has become a nullity. Right? Even please remember, section 33 of the same act says, where a candidate held any office in the government of India and dismissed within 5 years, then such person, right, he shall get a certificate from the election commission. Of course, if it is within 5 years, definitely he cannot be a duly nominated and his nomination cannot be accepted. So even though returning officer issued notices, this man did not reply properly. And he has made a double entry. One side he said yes, one side he said no, which is itself is confusing. Therefore, so please remember, here the Supreme Court is satisfied with the decision given by the Honorable High Court of Allahabad also, because initially they have made an elaborate study and dismissed the application in the initial stage itself. That means nipped in the bud. That's what I told you. The Supreme Court also commented like it's a good thing, because unnecessarily giving so much, because it is a complicated issue also, because everybody is thinking what will happen to Narendra Modi, why this election petition has come, and actually it is a sensational issue. Anyway, Supreme Court has decided it once for all, and now since the plaint is rejected, it is equal to a decree and he cannot go. He has to file a fresh petition if necessary. Thank you.